We might kick off. Hopefully everyone's had a chance to get a drink. If you need to get up during the night to go and get it, please do that. Don't feel shy about that. Thank you for all coming this evening, and thank you for those who are watching online as well. Hopefully you find the presentation tonight of some interest. I think either at the end of this or tomorrow or something, you'll be able to get the slides online somewhere, so don't fret if you don't take it all in. So tonight you'll have three speakers. Fahim Anwar will be talking. Now Fahim's going to talk about the recent Court of Appeal decision in Wipro, which deals with long service leave and in effect what service is taken into account in considering that. I will then talk about a couple of matters, principally the reverse onus under 361 in relation to general protections claims, but with a focus on corporate decision making. I want to touch briefly on the Qantas v TWU case, the one that will be heard in the High Court this year, and just briefly mention something about that and the interest of that. And then Oshi will finish up this evening with some future developments in the law of employment contract. And so we will probably have some time for questions at the end. So if you want to just hold the questions back to them, we'll do that. But with that, I'll pass over to Fahim to get us underway this evening.
Thank you, Jamie, and thank you everyone for coming. It's really great to see so many of you here in person today. As Jamie mentioned, I'm going to briefly talk about the decision of Wipro Limited. It's a significant decision because it has really overturned a line of authority that stood in New South Wales for about 50 years in relation to how you count service, and in particular to what extent you take into account service that's outside of New South Wales for the purposes of determining continuous service. And there was conflicting appellate level authority. There was conflicting appellate level authority within Australia, and now New South Wales has kind of gone the same way as Victoria, so it's looks like there's going to be some resolution on that issue. Now, before we look at the authorities, just to very briefly recap, under the legislation, Section 4.2 of the Long Service Leave Act says a worker who has completed at least 10 years of service with an employer is entitled to long service leave. Pretty straightforward. And then Section 411 goes on to define what service means. And relevantly, a service of a worker with an employer means continuous service. So as I said, the key question is whether there is continuous service if part of the service occurred outside of New South Wales. Now, the first significant decision dealing with that issue is the decision of Australian Timken, and you'll see from the citation this is a decision going back to 1971, so quite some time ago. And the facts are relatively simple. The employee in that case was engaged as an engineer in Victoria. Immediately after his engagement, he was sent to work for the employer's parent company in the United States. He worked there for a couple of years, and then he returned to Australia and was directed to work in New South Wales. And the key issue was obviously to what extent the service that occurred in United States, whether that should be taken into account as continuous service. Now, the Industrial Commission of the New South Wales in court session at that time held that at the time of occurrence of completion, termination or cessation of employment, you have to look at the service looked as a whole and whether that may fairly said to be a substantial extent New South Wales service. So importantly, the inquiry in that case was a retrospective one. So you look at when the employment comes to an end and you look back to see, looked at as a whole, can the service be said to be New South Wales service? Now, whether or not that's New South Wales service is a question of fact, and it will obviously depend on the facts of each case. But that's really where the substantial connection test, as it came to be referred to, was born. Now, and that's more or less where things stood for about 50 years, until this issue was looked at relatively recently by the full court of the Federal Court in the decision of Cummins South Pacific in 2020. Now, the facts of Cummins were the applicant in that case worked in the UK initially for Cummins for about 14 years. He then moved to Victoria and worked in Victoria for over a decade, around 12 years. And then he was seconded to work in the United States for, again, another 6 years, and then came back to Australia and worked in Victoria for another couple of years before his employment was terminated. Now, what the full court of the Federal Court, in particular Justice Bromberg, wrote the key decision, His Honour said that the substantial connection test, as applied in New South Wales, is a characterisation test, which essentially asks whether the service provided may be characterised as New South Wales service. And so he essentially applied that substantial connection test in Australian Timken, and he noted, well, Mr. Keenan had worked for the employer for about 34 years. And approximately 20 of those years were provided to Cummins, a Victorian-based company. 12 years was directly working in Victoria, including the last 1.75 years. So when you retrospectively look at the whole employment history overall, His Honour was satisfied that you would characterise that employment history as having a substantial connection with Victoria in that case. So again, as you can see, so that's sort of effectively a 50-year span where the law was pretty clear as to what test would be applied. However, shortly thereafter came the Victorian Court of Appeal decision of Infosys. And this is really the decision, I think, that started the move away from the line of authority started with Australian Timken. So in that case, the two workers had served for more than 7 years of continuous employment, and relevantly in Victoria, the relevant period of time is 7 years, not 10 years, as is the case in New South Wales. Now, both of those workers, their employment had actually commenced in India, so they worked for the employer in India for a period of time, migrated to Australia and worked in Victoria. And the period that they worked in Victoria was actually less than 10 years. And the Victorian Court of Appeal held an employee is entitled to long service leave by reason of completing 7 years of continuous employment with one employer. And that is really the central conception of the legislation. And ultimately, that central conception, that is the period of continuous service, is what has to have a substantial connection with the state of Victoria. As the worker's initial period of employment was entirely in India, that had absolutely no connection with Victoria, which meant that that period of employment didn't have a substantial connection with Victoria. And importantly, the Court of Appeal expressly said that the full court of the Federal Court's decision in Cummins was plainly wrong and should not be followed. And in particular, I think Victorian Court of Appeal made the interesting point, which is if the period of service in India is to be counted for the purposes of continuous service, you could have a slightly absurd result that someone could work in India for 6.5 years, come to Australia, and after 6 months they would be entitled to a long service leave. So that's really where matters stood. We had conflicting authority between Full Court of the Federal Court and the Victorian Court of Appeal, in particular Victorian Court of Appeal saying the Federal Court authority should not be followed. And that brings us to the very recent decision of YPro in December last year. Now again, facts are very similar. The employee worked for YPro in India before coming to New South Wales in that case, and worked in New South Wales for over 4 years. And after his employment was terminated, there became a dispute about whether or not the period of service in India should be counted. And again, the short answer is the New South Wales Court of Appeal just followed the position taken by the Victorian Court of Appeal. They agreed that the central conception is the period of continuous service, and ultimately that is what needs to have a connection with the state of New South Wales. Now, importantly, I think Court of Appeal noted that whether or not there is a substantial connection with the continuing service and the state is to be assessed when the service occurs. And this is really made explicit by Court of Appeal in a way that wasn't the case in the Victorian case, although I think it's implicit. So what that means is when the person is performing the service, you should be able to work out whether there is a substantial connection or not. And if there isn't a substantial connection when the service is being performed, then later service would not change the characterization of that earlier service. Now, connection could arise due to employment being performed inside New South Wales, or if it's in obedience to a direction emanating from New South Wales, or if the employment is formed in New South Wales. So connection can arise in a number of different ways, but however, when the service is being performed, the connection must exist. So what are the key takeaways that we can take from this decision? I think firstly, as I just mentioned, to reiterate, substantial connection has to be assessed at the time when service is performed. I think that's the first takeaway. The second takeaway to note, just because there are periods of employment outside of New South Wales, this decision does not actually say that the periods of employment outside of New South Wales is never to be counted. You always have to ask the question whether or not there is a substantial connection when the service is performed. And in a scenario where the employment started in New South Wales, and there was always an expectation that the employer would return to New South Wales, it is, quite likely that a substantial connection may be found, even though the service was performed overseas. And I think the final point I'll note, and I'll finish there, is I think in relation to the recent trend towards multinational companies bringing in workers from overseas, I think the impact of this decision is likely any service performed by those workers before they came to Australia would not be counted as continuous service, because in those circumstances it's difficult to see, unless in an extremely rare case, for example, if they were hired, say they were given a scholarship at an overseas university with the express intention of coming to Australia. In most cases, any service performed overseas before they came to Australia is likely not going to be counted as continuous service. So I think I'll leave it there and invite Oshi to come in, no, Jamie to come and talk to you about reverse onus.
Thanks, Fahim. It's always a bit of trepidation when you read these new cases and you think back into your early days of your legal career and all the advices you've given that have now become obsolete. So I know there's at least one or two out there based upon this decision, but it's outside the negligence period anyway. So so a few more people come in. Thanks for that, Fahim. I'll sleep better tonight as well. Now, as I said, I want to talk tonight about a couple of topics. The first one I'm going to touch upon is the reverse onus in the Fair Work Act. Now, as most of you who practice in this area will have come across in your claims in relation to the general protections under Part 3.1 of the Fair Work Act, this is one of the more important provisions, particularly in terms of the way you approach matters if you are acting for an employer or someone who's subject to one of these claims. My assessment is putting aside establishing workplace rights, like this is really the crux on which these cases turn upon in the court. So what I've set out here under is a couple of points or matters that you should note about the operation of the section itself. Now, I've highlighted a couple of these points just because I think if you're the benefit of when you're practicing it in it, one of the problems is you think about, well, if my evidence doesn't come up to scratch, is that the end of the matter or the end of the ability to rebut the reverse onus? The point is it's not, so you shouldn't be too concerned about it per se. So the first one, which we've identified here, is that, which is really the evident purpose, that is to put the emphasis and onus back onto the employers to give the evidence of the reasons why they engaged in the particular conduct. The second point I've set out there is that, and one of the first points I've highlighted is that in order to rebut the onus, you usually would, and can I suggest you should always get, but what the case is saying usually requires the decision makers to give evidence as to the reasons why they engaged in the particular conduct. Again, just highlighting this proposition usually requires, it's not a fact stated that you must, but suggestion is you should. And that point is picked up again, that the evidence of decision maker, again, usually required, but it's not a necessary precondition in order to rebut the onus. And coupled with that, the fourth point setting out there is that if it's rejected, that in and of itself, that is the evidence of the decision maker is rejected, that again, it's not the end of the road for you in relation to your case, but it's obviously something that would need to be considered in the overall determination. But really what the courts are saying is that when you look to see whether the employer has rebutted the reverse onus, you make that decision at the end of the case once all of the evidence is in, including the evidence of the decision makers and others involved in it all, and you have to weigh it all up to determine whether or not it has been rebutted. And the mere fact that you don't accept the evidence of a decision maker doesn't mean you can't rebut the onus. Now, you might be sitting there thinking, well, how does this happen? Well, there might be objective evidence that demonstrates that the allegation that something was taken for a prohibited reason isn't made out. Another example might be a circumstance where it's alleged that, it's a common in relation to adverse action, alleged a complaint was made. The employer gives a reason for the termination, let's say it's redundancy, and then the redundancy is challenged, and the court might find, well, look, we don't find it's a genuine redundancy, but it doesn't necessarily then follow that the reason for it was the complaint. It might simply have been one of those redundancies where the employer was trying to not really performance manage someone, but just move them out the door and say, look, it's a redundancy. So you can, that's another example where that might actually happen. You might say, look, it's a redundancy, that's rejected, but it wouldn't in and of itself follow that you can't rebut the onus. So moving on a little bit now. So the point that I wanted to just touch upon tonight is where this question comes up in relation to corporations. Sort of in my experience, this is the one that troubles employers, corporation employers, the most, because when you're sitting down to do the evidence, you're working out, well, who do we need to speak to in order to make this out and make sure that we bring the evidence to ensure that we don't fall over the hurdles of not having the relevant decision makers, and I'll come to that in a moment. or the people in relation to the decision-making process. The three most common cases that tend to be referred to in this context are the ones I set out, two here and the one over the next page. One is the NTEU and the Royal Melbourne Institute of Technology. And this was a case where a decision was made to make someone's employment redundant, but that was based upon a memorandum or report being prepared by someone else who recommended that approach. And the court in that case said that, well, if you're looking at the reasons of the corporation or the employer in determining what were the reasons for it, you need to, in effect, interrogate the mind of the person who recommended the decision to make the person redundant. The next, and that was a first instance decision of Justice Gray. The next decision there, Elliott, that's quite an old case, and it's a full court decision of the federal court. And again, this is another redundancy matter. I'm not sure why redundancy comes to the fore all the time, but it seems to be a common theme. But in this case here, there were two other supervisors of the employee who had made recommendations or gave rankings in relation to a number of employees, but one in particular, Mr. Elliott. And in that case, the court said that the employer's reasons also included the reasons of those individuals' supervisors. And here the court used the words who made indispensable contributions to the rankings. And I don't know, people have been involved in it all, but sometimes you have these redundancy processes go out and people are scored by technical ability, other sort of matters, how they interact with their colleagues and the like. So you get a whole ranking. And in this case here, the court had said, well, if any one of those other supervisors were motivated to give a ranking that was based upon the prohibited reasons, then that will have affected the decision because of the way that the rankings had in turn motivated the decision maker in their coming to their conclusion for the redundancy. And the last one, again, this is a single instance decision. I think it's Justice Reeves in Claremont Coal. And again, a circumstance where someone who had contributed to the process and where the inverted commas decision maker who was put forward by the employer had said that they couldn't have made their decision without referring to something prepared by someone else. And in that case, the court found that the employer couldn't rebut the onus because the court wasn't satisfied what was in the mind of the person who had contributed in that ranking spreadsheet. So have these three cases, as I said, they're the common cases that are referred to in looking at the corporate decision. Like the case I want to highlight in this context is the relatively recent decision last year, Wong and National Australia Bank. So that citation there is of the full court decision. The reason I wanted to highlight this is because of the decision of Justice Naden at first instance. This decision of Justice Naden is probably the first one that goes into a little bit more detail post Barclay and BHP Coal in this proposition of corporate decision making. Now, Justice Naden was overturned on appeal, but some of the things he said, and this is a point I'll often make, I think it's one of those things we need to watch out for because I think it's right for an appeal, properly engaging whether or not Elliott was properly decided in light of what the High Court has said in BHP and Barclay. And there is some support for what Justice Naden said, or some observations by Justice Lee in the Qantas case, which I'll come to before we end this. But in any event, at first instance, Justice Naden quite sort of rightly, and I think it's common for Justice Snowden to do this, but state where he's not, or state clearly that where he disagrees with other judgments or previous judgments, and doesn't seem to be concerned about doing so. And so here, you see this extract here, it says the reason those who significantly or indispensably influence such decisions ought not to qualify merely by reason of that influence as reasons that animate resultant corporate conduct. Now, as we'll come to see in a moment, what His Honour is really saying is that, look, when you're talking about a corporation, there's always someone who will ultimately have the authority to make the decision. Now, what he's saying is that just because you've got other people who might have spoken to that person, who might have had an involvement in the process along the way, when you're looking at attributing conduct, even using Section 793 of the Fair Work Act to the corporation, you really ought to be focusing on one person in particular, that person who had the authority. So that's Justice Snowden's view of how this all works, particularly post BHP Coal and Barclay. And he went on to say, look, he couldn't see how an individual officer might qualify as the maker of a decision on behalf of a corporation unless they could be said to have exercised some authority or executive power to effect it. So he's really identifying this is his view of how this thing should operate. If he's right about that, it makes life a lot easier for practitioners, because all you need to do is then go and identify who has the power here, who's got the delegated authority, who made the decision. You need not worry about going back down the chain and saying, okay, well, who did you speak to? What did you do? What did they contribute to this process? But in any event, having said all that, he quite correctly, as a first instance judge, noted that he was bound by Elliott and said that, and then went on to make some particular findings, in this case about Mr. Arnott, who he said accepted had in his words, a significant role in the process leading up to the decision. I can't remember who made the decision now, but it wasn't Mr. Arnott. But then, this is the point was picked up by the full court, said that whilst he had a role in this, he shouldn't be understood to have possessed any power or authority to actually make the decision, so that he should be understood to have jointly made it with the person who had the actual authority to do so. So on the one hand, he tells us this is how it should operate, says, look, I've got to follow Elliott, which says something different, and ultimately you can see where he comes unstuck in appeal, because that's what the full court said, is that whilst he's identified his view and then says that he has to follow Elliott, in the end he doesn't, and he applies his own view again. So anyway, you can see where the appeal is going to happen. In any event, he goes on, and this is effectively identifying those parts of the judgment, if you want to go and look at it in due course. So now just moving at the bottom bullet point there, so what is the relevant approach? So this is where we are at the moment, and this is really the full court's observation there in paragraph 78 of their judgment. And so looking again at this fellow, Mr. Arnott, whether he contributed to the, picking up the words here, the decision-making process. So we're not particularly using the words that we often use as shorthand, and the decision maker or their multiple decision makers. The court's focusing on the decision-making process. And they're using this word, adverse action, to a degree sufficient to warrant interrogation of his state of mind, and it's just an evaluation of all of the facts. It's really an old auditing lecturer years ago at university called evaluation weasel words, because they're trying to get out of giving any sort of guidance. But at the end of the day, you need to evaluate all of the facts. And picking up this point in light of the principles stated in the authority. So it is the authorities such as Elliott, it is the authorities such as Claremont, it is the authorities such as RMIT that one has to consider. And in relation to those authorities, we always search for a bit of certainty for our clients and for ourselves, trying to find, well, what is the test? Unfortunately, the full court has refrained from doing it, relying on another full court authority in the Australian Red Cross case. Said, look, it's unnecessary for us to summarise or give you one test or single formula. You need to look at it all and make the assessment, and then evaluate and say, well, looking at the process itself, who might have been involved in that process, what was their role in the process itself. So where does it all go for us? Well, depends on all the facts. Great, that's not much of an assistance to us. What do you do? I think the best thing to do is probably start at the very end and start with the person who did make the decision, and then work your way back. And what that really means is just working with those persons, kind of, well, what did you do in relation to coming to this decision? Did you talk to other people? Who did you talk to? Why did you talk to them? What information did they give you? Now, there is some, if you're trying to get a bit of guidance from some of these decisions, as the full court tells you, you need to go back and look at these authorities and what did we see out of some of these authorities? Well, in some of them we've got recommendations being made by others who don't actually make the decision per se, but a recommendation of the action. So if you've got a process where someone is recommending something to someone else, you probably want to get evidence from them. You want to be cautious about getting evidence from them. If you've got these assessment or ranking processes, you need to be alive to all of that as well, because you might likely have to get evidence from the people who are involved in giving the ranking or giving the score and interrogate their mind. In Wong itself, the full court was using language such as adopting the things that were done by other people. So I think that's really perhaps if you can, full court doesn't do it, but if you want to get some sort of formula or test out of it all, look at those circumstances where the decision makers are adopting something undertaken by someone else. And if they are doing that, then you're likely to have to get evidence from them, and you likely have to ask them, well, what were your reasons for doing that or coming to, whether it be a recommendation, whether it be a ranking, if it's been adopted by the decision maker. We might likely get a little bit more guidance later on this year. I know there's another case that is presently before the full court. It's going to be heard by, if she gets the time this year, Justice Raper in an appeal, where at issue there is where someone has undertaken a investigation process, factual investigation process. They haven't made any recommendations out of the factual investigation process, but have made findings based upon the witnesses they interviewed. And then the decision maker has taken as a part of the process the findings, the investigation findings, and put them to the employee and asked the employee to comment about them. And then as a consequence of that process, the employee has given some answers, and those answers have formed part of the view that the decision maker has come to. But what's squarely at issue in that case will be whether the investigation findings, merely referring to those, is enough to mean that the person who prepared the investigation report, and this could be, you can see the consequences of this, because lots of people farm out investigation reports to external parties. If it follows that they are persons you're going to have to get evidence from and interrogate their mind as to their reasons for coming to the findings, you can see how this is going to create a bit more of a nightmare in terms of getting additional evidence and the like. But that'll, as I said, if Veronica gets time this year, she'll hear the appeal in that matter. And so, as an aside, this is a matter that I want to talk about Justice Naden's view about this corporation identity, whether it's one person or not. In the first instance decision in TWU and Qantas, Justice Lee referred to what Justice Naden said in Wong, and he said that if there comes a stage where someone is going to argue that Elliott is plainly wrong, then what Justice Naden says by useful, or the points he said they usefully raised would have to be evaluated. For some reason, I can guess why they didn't do it, because it's quite hard to try to argue that a full court decision is wrong or plainly wrong. But it wasn't argued in Wong, and they probably didn't need to do it in Wong. But the point will come where someone will take it on. So this is a case I think we ought just keep in mind and watch for this sort of matter to develop. At some stage, the time will come, given that Elliott preceded Barclay and BHP Coal. Different legislation, but principles the same, but it's sat around for quite a while now without anyone challenging it. And often you get challenges to older cases that start with something like what Justice Naden's done. He's just put it out there. Another judge is going, well, actually, it's not bad. He hasn't rejected it outright. And Justice Lee's a pretty detailed judge in his judgments. And the interesting point about Justice Naden's judgment, I haven't highlighted it, if you can go and look at it, when he's talking about his view about who the decision maker is when you're talking about a corporation, he was referring to other authorities that attribute knowledge to corporations that are outside the Fair Work scheme. So there are other sort of authorities which support his overall view, which is inconsistent at the moment with cases like Elliott. So it's really a watch this space. So I want to move now, slight little segue, moving on from the TWU to the, and I touched upon this briefly, the upcoming High Court case. Now, most of you will probably be aware of the decision as it went up through first instance and then through the full court in relation to the baggage handlers case. And just to recap some of those points, Justice Lee, in his first instance decision, found ultimately that whilst Qantas had good commercial and financial reasons for outsourcing the baggage handling operations at its airports in Australia, he wasn't satisfied, however, that the decision itself wasn't also motivated for a prohibited reason, and the prohibited reason was to prevent the relevant workers from engaging in protected industrial action or bargaining for a new agreement the following year. And he did that on a number of bases, but in effect, he found he didn't accept the reasons of the decision maker were that reliable, and that some of the matters that had come up in some of the subjective evidence tended to suggest otherwise. And so Qantas appealed to the full federal court. They ran a number of points on appeal. Only one of them is now making its way up to the High Court, which is the interesting point of it, I think. And that's this proposition about whether or not, in order to engage the prescription in section 340, and in this case it was 341B, the question was whether or not the workplace right actually had to be in existence at the time. So going back to the example, the point in the Qantas case was that the right to take protected industrial action wasn't actually a presently existing right, because the agreement, one of the agreements hadn't passed its nominal expiry date, so you can't take industrial action. The other agreement that impacted employees had passed the nominal expiry date, but they hadn't taken the steps under the Act, notification, etc., in order to take action. So the point that Qantas raised, I think this is right, I think they raised this more squarely on appeal and they didn't run it at first instance, was that Section 341B, that's oddly what His Honour found, that there was that the contravention was committed through Section 341B. Qantas argued that couldn't have contravened the Act because there was no presently existing right. And there may never have been a right to take industrial action or protect industrial action. And so they argued that the decision was wrong on that basis. The full court obviously didn't accept it because we've now got an appeal to the High Court. And so this is now focusing slightly on what they're arguing in the High Court. And there's the point they're running, it's obviously a statutory construction argument, to say that Section 341B is what they call as a complementary provision to Section 341A, and that when it talks about preventing the exercise of a workplace right, they're saying that it's directed only to taking away those things that would allow you to exercise the right you currently have. So I think one of the examples whether they gave it in the full court or whether they give it in their submissions in the High Court is to say, for instance, taking the protected industrial action. Let's say there was to be a meeting at a particular time and place to vote on the taking the action. If you did some step to mean that those employees couldn't then go and participate in the vote, that's what they're saying that section is properly directed to. The union, as you can imagine, their argument is that that construction's too narrow. I think probably one of the strongest points against the Qantas's argument is that really Section 341A Roman numeral 1, which is that prescription where it says where you have the workplace right, has a workplace right if you take action because they have it, that would capture the circumstances of preventing the exercise of workplace rights. So if it is to be a presently existing right, so you've got the right, but if you do something to prevent them from doing it, then would fall within that. Now, on the special leave application, that type of questioning to Qantas from Justice Gleeson was pretty much consistent through her view that isn't this really what's picked up by 341A, and that if Section 341B was limited to circumstances where there was only a presently existing right, then it wouldn't have any work to do because of the operation of 341A, and so that on its proper construction, 341B would be operating on rights that might come into existence in the future. There are a number of other examples that the TW use in their submissions to support their proposition. One of them, common one is, for instance, taking parental leave, taking annual leave and things like that. You might not have a right to take annual leave until you give notice, etc. And you can see how taking action to prevent someone from doing all of that would seem to fall within the aim of the provisions if you construe them. But in any event, that argument will be had some stage this year, and hopefully, given how quick the High Court usually are, we might get a decision out of them before the end of the year. So now with that, I'll pass over to Oshi to finish us out this evening. And as I said, after Oshi's completed, we'll have any questions if you have any at that stage.
Am I allowed to ask a question now?
No, you're not.
Am I allowed to comment?
You can comment.
I can't believe they got special leave for that stupid point. I mean, let's put it this way. Here's Sophie. She's my employee. There's a risk that she might at some point become pregnant and take parental leave. I don't want to take that risk. I've got to get rid of someone from my team because I've got no work coming in or whatever. Is it going to be Sophie or is it going to be Fahim? I don't want to take my chances with Sophie going off for whatever number of years. So I'm going to keep Fahim and get rid of Sophie. So I'd be quite entitled to say openly, I'm getting rid of you because you might take parental leave, get out of here, and that's not adverse action because the right hadn't crystallised. What's the answer? You're not allowed to speak. No? I don't know. Just seems crazy to me. As does Snaden's view about that other thing. I mean, I've got to decide who to retrench from my workforce. I go to my supervisor and say, tell me who I should keep and who I should get rid of. Supervisor hates Fahim because he's a member of the whatever union, the shoe fixers union. He comes along and gives me the list and says the first person to get rid of is Fahim. I don't ask him why he's put him at the top of the list, I just act on it. That's not adverse action because I just didn't bother to interrogate the reasons why that person was at the top of the list. I don't know, I don't get it. Anyway, I think that's the end of the practically useful part of the afternoon, and now you can just listen to me talk about things that I'm interested in that don't really help you in the conduct of your practice, but it's too late. You're here now. It's going to be really awkward if you try to leave. I think it's the fun part, but that might depend on your concept of what is fun. At the risk of upsetting the Iron Fist Jamie here, can I just ask, have a quick look at this quote. Is anyone willing to guess where this comes from? Is it an academic article? Is it a case? Is it a commercial case? Is it an employment case? What's this about? Lauren? Is it a case?
No, it's a case.
No? Why not?
Judges don't write like that.
Too airy-fairy?
Is it ChatGPT?
It is not ChatGPT. Great guess. Someone's up with the times. Does anyone have any other view? All right. We'll come back to that. But look, the reason that I could tell you it is from a case, but the reason that one might wonder about that is that it's not. Well, it seems a bit uncommercial and non-legal to talk about normative standards of conscience, acceptable community values, honesty and fairness in the dealings with others, development of norms over time, customary morality and so on. I would guess that if you spoke to a layperson, they'd say, yeah, this is what law's about, fairness, justice, etc. But if you spoke to a lawyer, they'd say to you, this has got nothing to do with it. And if you spoke to an employment lawyer, they would definitely say to you, this has got nothing to do with it. And you go into court and start saying, there's been a breach of contract because of a contravention of community norms in honesty and fairness in dealings with others. You'd have a pretty good idea of how that's going to go. But we'll come back to that. What I actually want to talk about is the sort of trajectory of employment law aside from the Fair Work Act and collective action, which is what we often think about, but reality is probably for most of us, if you act for employers, most of them are not that concerned about awards and bargaining and multi-employer bargaining, all the rest of it. It's really more you're living in the world of contract. And I just want to talk a little bit about what's happened there over the last few years and what might happen next. Can I just say something about what's happened overseas, especially in the UK and other common law jurisdictions? those of you who studied law in the early 2000s, like me, might remember that Malik and BCCI was the big thing in employment law. And that was the decision of the House of Lords which discovered or invented, or you could put it different ways, the implied term of trust and confidence as a term implied by law into all employment contracts. And the term was along these lines: an employer shall not, without reasonable and proper cause, conduct itself in a manner calculated and likely to destroy or seriously damage the relationship of trust and confidence in employment. And this was said to place a portmanteau. I looked that up. It means luggage case for the carrying of clothes, especially one that divides into two. So what that means in this context, I don't know, but anyway, the term creates a general obligation not to engage in conduct which is likely to undermine trust and confidence if the employment relationship's to continue. And it was a really big deal at the time, and it in fact in the UK and in other jurisdictions where it's been adopted, it has been really important and part of what's been described as the employment revolution. The logic of it is this: the relationship of employment requires trust and confidence because it's cooperative, etc., etc., etc. That is what the contract is for, to embody and give effect to a relationship of that kind. Therefore, conduct which undermines trust and confidence is destructive of the thing which the contract is giving life to. Therefore, it must be, by necessary implication, that anything that destroys trust and confidence, thereby destroys the contract, that can't be permitted, therefore there's an implied prohibition on it. That's the logic of it, and obviously it starts off with a large proposition that the employment contract is about trust and confidence, but that's, in grossly oversimplified terms, the logic that led to the conclusion. And it was a big deal because it was said to be and was a broad obligation that goes to anything that affects the continuation of the relationship, and it's really about the conduct of the relationship. Sometimes it can bear on termination, although that's a little bit complicated. And it was said by one of the judges of the House of Lords, who was part of the bench but in a different decision, that the contribution of the common law to the employment revolution has been by the evolution of the implied terms in the contract of employment. And it was Hoffman, I think, who said the most far-reaching is the implied term of trust and confidence, but there have been others, and in the UK there are a few others. And it, as I say, it was a big deal, among other things, because it effectively gave each employee the capacity to litigate as a contractual cause of action questions of fairness and whether conduct had breached the implied term or had attacked the foundation of the contract in trust and confidence. And that could be applied in a wide variety of scenarios. And in Malik itself, the contractual claim was that because the bank that he worked for had turned out to be really dodgy and had gone under, and it was in the news and everyone knew that they were the worst people in the world, for him as an employee, his future employment prospects were destroyed through his association with that dodgy behaviour, and he said that was a breach of his employment contract and succeeded. So if that can get home as a contractual cause of action, you can imagine a lot of other things that happen all the time that would much more easily fit into that rubric. It was quite openly said or acknowledged at the time that the rationale, or part of the reason why it was necessary, was to protect employees. And Steyn, who, again, in a different decision, but I think he was in Malik, said that there was a need to protect employees, an increased need to protect employees for a whole variety of reasons, including deregulation of the labour market, privatisation, globalisation, and a whole bunch of other things. This is a member of the House of Lords, by the way, not your local friendly union official. And in Australia, the South Australian full court of the South Australian Supreme Court said that the development's consistent with the idea that the relationship is not one of subordination but one of partnership. And the point is that all of that development, and bearing in mind that well established in the UK, picked up in Hong Kong, Singapore, places that aren't necessarily workers' paradises, so it wasn't some completely idiosyncratic thing. The reason for it all was a view that there was a need to effectively reshape the employment contract to protect employees by requiring fair dealing and a cooperative approach. So that's what's been happening over the last 25 years overseas, one of the major developments. Back in Australia, there's been a similar development in business. Not a development driven by the courts necessarily, but by Parliament. So there are any number of examples of this, but an obvious one is statutory unconscionability. Now Section 21 of the Australian Consumer Law. There was a provision in the Trade Practices Act before that, so not brand new, but fairly recent. And it's a prohibition of conduct in trade and commerce, which is unconscionable. Now, it's limited to the supply or possible supplier acquisition of goods or services, but that's a very broad category. And I'll just, thinking of the time, zip through this. The legislation makes it really clear that statutory unconscionability isn't as narrow as equitable unconscionability, which is really difficult, where you have to have special disadvantage and there has to be notice of it, and it's really a pretty niche thing. Statutory unconscionability isn't limited in that way. It can pick up a pattern of behaviour or a system. The court can look at the terms of the contract, the way that the contract is performed, and it's not limited to, and it's looking at unconscionability in supply, presumably pursuant to a contract, but it's not limited to looking at the position at the time the contract was formed. There are a whole series of things the court can have regard to: relative strengths of bargaining positions, customs understanding, undue influence, consistency in conduct, the capacity to which the contract terms were negotiated, so whether it's a standard form contract of adhesion or something that was genuinely negotiated, and a whole series of other things, whether there's been conduct in good faith, and so on. And if that seems kind of like it introduces all those concepts of fairness and good faith dealing and trust and all the rest of it, it does. And the quote that we saw at the start was a decision of the full court of the Federal Court in a statutory unconscionability case. And they said, when we assess compliance with this standard, we think about these things, all those things that seem quite non-legal and not technical and, things that lawyers wouldn't normally concern themselves with. They were the things that the full court, led by the Chief Justice, said bear directly on the issue. And again, this has been cited in any number of cases and is good law when it comes to statutory unconscionability. There are provisions dealing with unfair contracts that bring in a lot of the same sort of thinking. The Contracts Review Act in New South Wales is very underutilised for reasons which I don't really understand, but anyway, similar sort of broad approaches that allow a court to think about good faith and equality of bargaining power and all those sorts of things. Meanwhile, in the world of employment, we're on a different trajectory. And so I should have said that the ACL provisions that I've just been talking about specifically exclude contracts of employment, effectively. So a lot of these cases about employee independent contractor, I do wonder why someone didn't just say, yeah, they're a contractor, and so we can claim unconscionability under Section 21, but anyway, it doesn't matter. In the world of employment, we're going in a different direction. The unfair contracts jurisdiction in New South Wales has been abolished. Does everyone know what Section 106 was? No? it's funny because there was a time where 106 was, put roofs over the heads of every employment lawyer in New South Wales. It's now forgotten. Then we had Barker, that the implied term of trust and confidence had sort of been floating around. It had got a bit of support here and there, got some support in the full federal court in Barker, and then was destroyed by the High Court in Barker. And the short point is they looked at Malik and Unisys and some of those decisions of the House of Lords that we looked at earlier, and they basically said the way that these things were discussed points to a specific societal context and considerations which, if they exist in Australia, I mean, why wouldn't they? But anyway, if they exist, would ordinarily be directed to legislatures, so that a judicial announcement of that kind would involve the courts taking on a regulatory function by reference to a normative standard, like the one that Chief Justice was talking about in the case we saw. But they said the courts deal with this, obviously they do, but to create that as a new standard is a step that wouldn't be taken lightly, and as we know, is one they weren't willing to take. They pointed out some of the breadth of the concept and said it's the implied term reflected a tribunal's view of good industrial relations practice. I don't know what that means, but it seems kind of pejorative. And in the end, they said if this is going to happen, it's going to have to be Parliament. It's not going to be us in the courts. It's just too large of a step. We're not going to follow the communists in the UK House of Lords and the Hong Kong Final Court of Appeal and the Singaporean High Court. Parliament's going to have to do it. JAMSEC and personnel, you probably all know about, but just to highlight a couple of things, the only kinds of rights which the courts of justice are concerned with are legal rights. The employment relationship is a legal relationship. It's not social or psychological like friendship. I don't think anyone was saying anything about friendship, but and ultimately there's nothing of concern to the law that would require treating the relationship between the parties as affected by things that have no bearing on legal rights. So employment it's just another contractual relationship. We don't look at it any differently. It's just about legal rights. What's your contractual rights? Where do we find them in the contract? Are you talking about something that's in the contract? No, then the courts have no work to do here. This is a really dry exercise of identifying exactly what you've signed up to, usually in the document itself. Apart from that, we don't care. That's in employment, and then in commerce, you've got this stuff about honesty, fair dealing, all the rest of it. So on one view, a bit of a strange scenario. I am conscious of the time, and I'm getting there. Okay. But a couple of developments. Pay secrecy provisions in the Fair Work Act. A couple of interesting things about this. One is, I'll be corrected if I'm wrong about this, but as far as I can't bring to mind any other provision of the Fair Work Act that deals with the employment contract directly, that regulates the employment contract. It might overlay a whole bunch of obligations on the contract, but I can't think of any other provision which declares void, as the pay secrecy provisions do, a term of an employment contract. Am I right about that? Am I, Justin?
Deductions from employees' pay are void.
Is that right? The term of the contract is void if it purports to authorise. Yep, no, that's a fair point. Yeah. Is there another one, Justin?
Just say 326.
Okay. It's the second term of the Fair Work Act that addresses the employment contract directly. That's one interesting thing. And the other interesting part is that the rationale for the change, as I understand it, is partly a concern about gender pay equity on the basis that pay secrecy provisions allow the gender pay gap to, among other things, allow the gender pay gap to continue. So it's not so much a general sort of industrial, maybe gender pay equity is an industrial concept, but it's quite specifically directed to that policy consideration. The government's announced that they're watching closely what's happening in the US when it comes to restraints. There's a proposal in the US by the competition regulator, not the National Labour Relations Board or anything like that. The competition regulator says we've got to get rid of restraints because they're an unfair method of competition, and because I've revealed the punchline. And they've said they're about these things. They're about hampering productivity. They're about the change would promote competition. It would assist consumers. It would avoid price increases in some sectors. So again, it's not a question of fairness or about doing the right thing by employees only. That's part of it, but it's a dry economic policy issue as well. And this is the stuff that actually probably would have been useful to you, but I'm just going to skip over it. But anyway, that they're proposing that non-solicits are fine, but non-competes will go completely for anyone, everywhere. Just can't do it, not even a month or a week or whatever else. Would apply to contractors as well, and would apply to existing employment contracts. So they're a little bit more bullish than the Australian regulator and the Australian Parliament usually is. And there's an exception for sale of business, which is probably fair enough because a lot of the time purchasers paying a premium so that you go somewhere else and don't come back and undermine the value of the business they just bought. What's the point of all this? Andrew Leigh, he gave a speech to Maurice Blackburn, which is online. It's the only politician speech that I've seen that has footnotes and like Harvard citations. He's just a huge dork, but he's an economics dork, right? He's not an industrial employment person. He's an economist, a kind of lefty economist, but an economist. He pointed out that he introduced the ban on unfair contract terms. Should have said they apply to standard contracts, which means contracts of adhesion that aren't negotiated. Sounds a bit like most employment contracts to me. I mean, theoretically they can be negotiated, and I once negotiated a restraint out of my employment contract, but usually people are just signing whatever's put in front of them. Anyway, he says he introduced into Parliament the ban on those terms. He said it won't deal, because it doesn't cover employment contracts, it's not going to deal with this non-compete issue, and he was talking about how they're watching what the Federal Trade Commission's doing in the US. Then he said, why should we ban unfair contract terms when it comes to a big business contracting with a small business, but allow unfair contract terms when it comes to big business contracting with an individual employee? Now, there might be a lot of good reasons why you would. He didn't answer them. I don't know what the answer is, but it's a question that's always occurred to me looking at those unconscionability, unfair contract terms cases dealing with business. And I mean, they're consumer protection rules, but there are a lot of people out there litigating statutory unconscionability who aren't grandma going down to the, to buy a car and getting a dud used car. A lot of them are big commercial players. Why do you have those rules that Allsop was talking about in terms of community norms and all the rest of it operating there? And then in employment, which the layperson would think is all about fairness and cooperation and partnership and all the rest of it, you've got a completely different approach. Certainly for those of us who are lawyers paid by the hour, we should pray for the provisions to be expanded into employment, because it'll be a lot of work for everyone. There are probably other considerations beyond that that the Parliament should think about, I guess. But
saving my practice one, they shouldn't be imposing those restraints.
I think your practice would be fine. Although, I mean, you're right, it would be very bad for the restraints, it would be bad for me too, so maybe they can keep the restraints and introduce general unfair dealing provisions. So the point is, I don't know what's going to happen, but it would be interesting to see if Andrew Leigh's thought bubble that he just left hanging out there gets any traction. Thank you.
Well, thanks very much for coming. As I said, your chance now to have some questions of any of us, if you'd like to. It's your, here's your free chance. You don't have to pay for it, so could be on anything.
I'm not answering questions on anything.
If not, please stay around if you can. There's sure there's more alcohol and food over there, so
Here as I can see it.
yeah, well, it could work. So stick around and hopefully you can have a drink with us. And if you've got any questions, not now, but while you're having a drink, then come up to us. So thank you.